Over the past several days, the Trump administration has taken increasingly drastic steps in response to protest activity and unrest in Los Angeles, including federalizing 4,000 National Guard troops and sending 700 Marines against the objections of California's state and local leadership. As events unfold on the ground in LA and in the lead up to further anticipated protests, Just Security and the Reiss Center on Law and Security hosted a panel of top experts to examine the pressing legal and policy issues at stake. I'm Ryan Goodman, founding co-editor-in-chief of Just Security and faculty co-director of the Reiss Center on Law and Security at NYU School of Law. I served as moderator of the June 12th panel. The three panelists were Liza Goitan, the senior director of the Liberty and National Security Program at the Brennan Center for Justice, Mary McCord, the executive director of ICAP, the Institute for Constitutional Advocacy and Protection at Georgetown Law and a member of Just Security's Board of Editors, and Steve Vladeck, the Agnes Williams Sesquicentennial Professor of Federal Courts at Georgetown Law and Executive Editor of Just Security. So I thought to start out our discussion not on the law, and turn to you, Liza, first, just to lay out what are the normative policy implications of what we're talking about, because you had a terrific tweet thread that went viral as soon as the president had issued the memorandum on Saturday. But in the tweet thread, there's this moment where you take a step back and you talk about what the implications are, just for in layperson terms, that aren't necessarily connected to whether or not this is lawful. Can you start us out with that?
Sure. So, without talking about the law as a technical matter, but rather talking about the reasons for the law, right? The reason we have the Posse Comitatus Act. Yes, it was passed in 1878, but it embodies a centuries-old tradition in Anglo-American law against the military participating in law enforcement activities. And the reason for this is that if a leader can turn the military inward against the people of that country, that can be a powerful instrument of oppression and tyranny. So this law is a vital protection for individual liberty and for democracy. So then if we look at what is happening in Los Angeles and what the president has done, he has not only deployed the military to effectively police protests. I know they're saying they're protecting federal property. We'll talk about that later. In a situation where, yes, there was some violence, there was some vandalism, but it was being handled by state and local law enforcement successfully. And that is who is supposed to handle civil unrest in our constitutional system. So not only was this inappropriate with respect to Los Angeles, again, we'll talk more about that, but his memorandum authorizes the deployment of federal forces anywhere in the country where protests against ICE activity are occurring, regardless of whether there's violence involved. That's not a criterion in the memorandum, or where protests against activity are likely to occur in the future. So this is a preemptive nationwide deployment to effectively police protests. Unless we think this is limited to ICE actions, President Trump 2 days ago said that any protester who came out to protest the military parade this weekend would be met with very heavy force. So what we are talking about is, it is not about acts of violence. It is not about making sure that federal law can be enforced. It is about suppressing dissent and disagreement against the government. And that is probably the most fundamental right that we have in a democracy.
Thanks. And with that, I do want to now kind of foreground the legal issue of the First Amendment. Mary, if I could turn to you for that. So the question is, what we're seeing here, is there a First Amendment violation on the face of it? In terms of the memorandum, as Liza just says, on its face, it says that it is a rebellion either on the basis of protest or acts of violence, so protest alone could do it. And in the preemptive use of force around the country, it says that it's an authorization to use the National Guard and the standing armed forces for protest activity that could interfere with the enforcement of law, just protests. That's one part of it. And then, as Liza said, in the Oval Office, the president in the last 48 hours said, and I have the direct quote, I also picked up on it, he said, quote, and he's talking about the military parade that's going to take place this weekend. Quote, for those people who want to protest, they're going to be met with very big force, end quote. And then later he also says, quote, with very heavy force, end quote. How do you think about the First Amendment issues? How should we be thinking about the First Amendment issues? Marianne, what if, for example, the president's statement were in fact written into the memorandum itself? Would that be the tripwire for violation of the First Amendment that could actually find its way to a successful court case, for example?
Sure. So, we started off by talking about the reason for the protests, of course, are because of ICE raids that are taking place across the country, and particularly these protests in Los Angeles. So that's core First Amendment protected activity, right? First Amendment doesn't protect acts of violence. Those are, those things would be outside any First Amendment protection. But clearly many of the people protesting are not engaged in acts of violence. So I think First Amendment facial challenges are hard. And this is also not a regulatory executive order, right? It's an executive order that's not purporting directly to regulate people's right to engage in First Amendment protected activity. It's not purporting to create a new crime, for example, that involves protests that inhibits the execution of the law. It's just saying, here are the situations, I shouldn't say just because that minimizes it, but it's saying, here are the situations where I am authorizing, I, the President of the United States, am authorizing the federalization of the National Guard and the deployment of US military forces. So right there, it's a little bit different than what you normally think of as a direct First Amendment regulation that potentially could be facially challenged. And the grounds something potentially can be facially challenged on would include, in the First Amendment context, things like overbreadth and vagueness. And here, I want to go back to the language because it's important. It says, to the extent that protests or acts of violence, so it could be one without the other, but here's the next part, directly inhibit the executions of the laws, they constitute a form of rebellion against the authority of the United States. So it is also clear that there can be restrictions on First Amendment protected activities when those restrictions are content neutral. In other words, they're not based on the viewpoints of the First Amendment or the content of the First Amendment, and where they fulfill a compelling governmental interest. Execution of the laws of the United States is something that the government would advance as a compelling governmental interest. Protection of public safety, including not just law enforcement officers, but also members of the public that could get caught up in acts of violence, also a compelling government interest. There can be content neutral time, place, and manner restrictions. Things like don't block highways, don't block sidewalks, right, without a permit for those things. Don't block the entrances of places. So restrictions can be upheld on those types of grounds. And here, even assuming this is a restriction because the impact of it is a restriction, even though it's not a direct regulation of speech, I think there are questions about its vagueness and its overbreadth. What does it mean, for example, to directly inhibit the execution of the laws? Does that mean forming a barrier so that ICE agents can't get to the people they are trying to talk to or arrest, assuming for a moment that they've got legitimate authority to do that, but actually don't have to assume that, because that would be a different issue of law and a different matter of due process if they were not complying with the law in those arrests. So that, is it that kind of a thing, or is it something that's much more attenuated than that? So these are the things that when there are regulations of speech, particularly with consequences like criminal consequences, sometimes can be challenged because a person has a right to know exactly what they do that could trigger criminal or other repercussions. And here, I think it's vague what it means to have a protest that directly inhibits the execution of laws. All of that said, I think a facial challenge to this would be challenging. To the president's statements, the president has made lots of statements about a number of topics since January 20th and before. that are inconsistent with things that the Department of Justice lawyers have said in court when they are responding to litigation. That includes litigation about the alien enemy, use of the Alien Enemies Act to remove alleged members of Trinidad from the United States to a terrorism detention center in El Salvador, as well as other removals. Many different things that the president has said that get raised in litigation to show what his true sort of intent is and what the true import of what he's doing is. But then the lawyers will often make legal arguments in court that are something different than that. And the courts have so far not been willing to go all the way to the point of saying, we're just going to base our ruling and evaluate the legal issues based on the facts of what the president is saying outside of the court when there are other facts that are being presented in court. They're not ignoring it, but I think it would be tough to say what he said the other day is sufficient to make a First Amendment violation. If he put that in the directive, we'd be closer to the things we've seen with the executive orders blacklisting law firms, right? Where he makes it very clear in the first paragraphs that he is retaliating against a law firm for the causes they represent, the people they represent, and the people they hire. Like, it's blatant on its face that it's First Amendment retaliation. So something baked in could be treated differently, but this one is pretty vague. And again, doesn't even talk about Los Angeles. It could be, as Eliza said, anywhere in the country.
Great. And then Liza or Steve, do you want to jump in on that at all? And one question I might ask, just as a kind of further deepening of the First Amendment concerns, is there conduct that the guard could carry out, and that conduct then would be the kind of First Amendment right that's more cognizable in court, like detaining somebody on the basis of their protest activity or something like that? Is that the kind of application of the memorandum and the authorization of force down to the practice on the ground that might change the outlook for First Amendment type claims?
Sorry, Lonnie, go ahead.
You go first.
I mean, I think it's important to come back to a point that Mary made at the beginning, which is, nothing that the president has done to date changes the laws that apply to people on the ground in Los Angeles, right? And so it's the same criminal laws that are still in effect, whether it's a matter of, city, state, or federal criminal statutes. It's the same constitutional protections. It's just different people who are implicated by potential violations of those laws. And so, Ryan, I think it would, the problem I have, it's not a problem with the question, it's a problem with the scenario we have, which is, what really to me is a big trigger to look out for is when troops on the ground, whether they're federalized National Guard or Marines or active duty Marines, are actually doing things that ICE officers or FBI agents could not do. Right, that to me is where you have really stronger arguments beyond just that the deployment of troops might be unlawful on its face, that this particular conduct is implicating First Amendment concerns in a way that if it were an ICE officer or an FBI agent, it wouldn't be. Right, I think two different things are going on. The first is a series of confrontations between federal officers of lots of different stripes and protesters, where the rules ought to be the same. And then the second is the question of when can the federal people on that side of the equation be in uniform versus when do they have to be FBI, ICE, or other civilian law enforcement officers?
Yeah. And just a couple of quick things. One is that the memorandum does talk about, in terms of citing the legal authority and explaining why it applies. It talks about, to the extent these things actually cause direct, interference in these law enforcement functions. But then when it talks about what's being authorized, it doesn't, it just says any place where protests occur. It doesn't say as long as those protests are directly, you might be able to sort of import that from the context, but the actual language of it just says any protests, including places where protests are not occurring so they really couldn't be interfering. So that is, and totally agree, his sort of off the cuff statements about what's going to happen in DC. Yeah, that's not going to mean much in court, I think. And frankly, something in the memorandum that says I am authorizing deployment for any place where there might be protests. you're not going to be able to bring a claim before that's been enforced, and until you see how it's being enforced, as Steve said. But what I do want to just say about all of this is that there was a woman who was interviewed on BBC, on a BBC program in Los Angeles, who said, "I came out to protest, but things are getting hairy. I'm worried I could get arrested. The military is here. I don't need this. I'm going to just go home because I'm scared." So this is, and of course that's not, well, I don't know if I should say, of course, she doesn't have a case. There's precedent, Laird v. Tatum, that a subjective chill is not sufficient to have standing to sue, even if she had a legal First Amendment claim on that. And yet, right, when we see thousands of people, which we will, making that exact same determination and staying home when they would have gone to protest, the First Amendment ramifications of that are huge. So we talk about sort of the law versus the bigger picture of what's happening. Like legally, yeah, there's probably not a lot to be done right now on the First Amendment, but we are seeing the First Amendment effects. We are seeing them play out.
So I want to underscore something Steve said, and then pivot off of something that you all said about what courts might do versus what the law might say. But just to underscore something Steve said, part of our conversation here, I think, is also about the existing authorities or authorizations for the use of the National Guard and the Marines compared to what might otherwise happen if the president invoked the Insurrection Act, which has not happened yet. But what Steve said, in the sense that even if either of those two scenarios take place, the one we're in or the Insurrection Act, it doesn't change people's constitutional rights. The Insurrection Act does not modify or suspend rights. It's just saying which particular forces, military versus civilian, can be used to implement the law. We published a piece at Just Security by Dakota Rooshill, which was an evaluation of a popular movie that's out in the last couple of years called War Games. And in the movie, it's a good movie, but at one point it says, oh, and if the president invokes the Insurrection Act, it'll be martial law and people's civil rights will be suspended. And what Dakota says is that's not true. What Steve said is true. So I want to talk about, pick up on something that you all have talked about or mentioned, which is what the courts might do. And I think it might be important in clarifying to people to separate out two things. And Steve, maybe I'll turn to you first and tell me if you think I'm right, or just prompt you with this idea. The courts might not find the authorization of the National Guard and the Marines unlawful for a host of different reasons, like the person doesn't have standing. The courts give deference to the executive branch. The courts treat it as a political question, and then it's purely a question by the president as to whether or not, for example, the facts on the ground meet the standard of definitions of rebellion or things like that. And they say, look, that's not for us. We're not going to second guess the president. But what I think is maybe important in clarifying is that doesn't mean it's not illegal. Those are like judicial doctrines of deference and the like. And there's a separate question, which is just simply, is it still illegal? Is it actually, do the facts meet the standard? And there are different people. There's the public that listens to this question and just wants to know, is it legal or not, independent of how the courts might come down on that. And also US government lawyers, internal to the executive branch, that are supposed to check off the boxes that all of the different aspects are legal. Can you talk about that issue? Because I know that's something that you think about a lot.
I can try. So I think the first thing to say on this is maybe perhaps to distinguish between the different types of legal questions that are being implicated, and then to sort of dive in, right? So it might be helpful to break apart two different questions. And the problem is that chronologically, they arose backwards. So the first question, I think, analytically is, can the president deploy active duty federal regulars, which is the colloquial term for folks who are already in the federal military, right, in response to what's happening in Los Angeles without invoking the Insurrection Act? And then the second question, although this came up first, is can he federalize California National Guard troops, one, in general, and two, even without Governor Newsom's permission, right? And part of why this is tricky is because, as Liza pointed out, the president has not invoked the Insurrection Act. It actually might be more straightforward from a procedural perspective if that had happened. Instead, this is sort of short of that. And at least so far, the government's argument is that this is all justified as exercises of the president's Article 2 power to protect federal functions. That power, right, is sort of not one we spend a lot of time talking about normally, but it's not made up out of whole cloth. There's, this 1890 Supreme Court case in Ray Nagel, where the court said President Cleveland did not need a statute to assign a marshal to protect Justice Stephen Field from an attempted assassination. The Justice Department over the years has interpreted that ruling perhaps more broadly than it can bear. But Ryan, I think there's at least some consensus that there's a Article 2 protective power, and the fight is over just how far it goes. So this is where we run into, Ryan, why your legality question is so important. In any other administration, that very same part of the Justice Department, the Office of Legal Counsel, would presumably have been deeply and intimately involved in putting forth the legal justifications for what President Trump has done to date, and answering questions about what the troops can and cannot do once they are utilized in this fashion. But we know from public reporting that this administration has made a habit out of bypassing the Office of Legal Counsel. And so we can't be certain that that's happened in this case, right? It's possible this is just coming from the White House counsel's office and maybe a handful of DOJ lawyers now that there's a lawsuit. So legality in this context, yes, is multifaceted. I would say, first, there are hard questions about which government lawyers signed off on this, right? Second, there are the procedural questions about what role, if any, Governor Newsom is allowed to and or required to play with respect to those of the troops who have been federalized under the statute 10 U.S.C. Section 12406. And then it strikes me there are two substantive questions. The first is, in general, is this an appropriate use of the Article 2 protective power? And then the second is, specifically, are these the circumstances that 12406 authorizes federalizations in? And those questions are all implicated to some degree in the lawsuit that Governor Newsom has filed in the Northern District of California against President Trump. That case was assigned to Judge Charles Breyer, who just happens to be Justice Stephen Breyer's brother. Right, Breyer's holding a hearing this afternoon at 1:30 Pacific time on California's request for a temporary restraining order. I think, Ryan, we should get comfortable with the possibility that the courts are going to be wary of getting too far into the substantive questions in these cases, that they might rely on the procedural ones, but that the procedural ones might be sort of transitory, in that even if there were I's that President Trump didn't dot and T's he didn't cross, that's fixable. And the broader substantive questions, I think, are going to be sort of harder to fight, worth litigating, but where the courts might be more reluctant to dive in.
Ryan, before we get into those issues, can I say something else about sort of like the normal internal government process? Because certainly when I was in the leadership of the National Security Division, I had a lot of different levels of involvement with not only the Office of Legal Counsel, but also the lawyers group. So it's not just some Justice Department lawyers who in normal administrations are asked to review any type of executive action. And that's why we've seen multiple Office of Legal Counsel memos over, history opining on questions directly related to use of the military, not only for limited to protective powers, but also under the Insurrection Act. And back in 1957, when President Eisenhower sent the military into Little Rock, Arkansas, very much over the objection of the governor there. But there's also a lawyers group where on decisions that do involve the military and national security, it's not just some Justice Department lawyers that weigh in, it's lawyers from all of the national security departments and agencies, including our intelligence community and including the Defense Department, right? Because these are really important decisions to be made. And I can tell you in my experience, there's a couple of things that are happening when the White House is asking for an opinion or something. One is that the Office of Legal Counsel and the government attorneys are wanting to maintain always robust executive authority, right? They don't want to give away any executive authority. So you will see throughout Office of Legal Counsel opinions on these topics, a lot of discussion about inherent presidential authority when it comes to use of the military domestically, particularly in emergencies or rebellions, insurrections, etc. But so the Office of Legal Counsel and anything that they actually write up as an opinion, they're wanting to preserve that space. But at the same time, at least in past administrations, there is oftentimes, at least in recent history, other than the Trump administration, a desire to not go as far as their argument would allow the government to go or the president to go, right? Out of other prudential reasons. One, to show we're not even exercising that vast constitutional authority that we believe exists. Congress has provided statutes, Insurrection Act, Posse Comitatus Act. So oftentimes the recommendation will be to do something that is less than what the Department of Justice and Office of Legal Counsel is wanting to preserve. And I think that's important here because potentially that explains this use for protective powers now rather than invocation of the Insurrection Act. On the other hand, as Steve said, I have really no reason to believe that this White House is going to the Office of Legal Counsel, much less to the lawyers group that involves all the national security lawyers before it takes this action. We don't know that for sure, of course, but it is consistent with history to start with the lesser before you go to the greater. And I'm not suggesting that this is not still a step one in what's potentially dangerous escalation, but that's just kind of like historically the approach that I've seen in my experience at DOJ.
Yeah, no, in fact, I was going to ask you, because you've had a vast experience there, almost like none other. Just to add to that, I was just looking it up now to get the exact one. On April 4th, the New York Times, Charlie Savage has this great report. It's titled Trump Sidelines Justice Department Legal Office. And it's a very detailed investigative reporting on his part about the Office of Legal Counsel being excluded from the normal ways in which it's relied upon in this administration. And then I think this is a good moment to do something I hadn't thought about doing in this part of the conversation, but where we're at in the conversation, I think it's important, which is to think about and talk about the government's brief that was just filed yesterday in response to the Governor Newsom, California's request for a temporary restraining order. And this plays right off of what you just said, Mary, and invite any of you to comment on that. The way I read the government's brief is that they are, in fact, doing what Mary just described, saying, look, we are not having the National Guard engage in any law enforcement activities. Because if they were, then you've got a serious posse comitatus, not even just serious, that would be like a posse comitatus violation. So the very fundamental laws that Liza mentioned at the beginning and why they're there in the first place. So they say, we're not doing law enforcement. We're only doing this narrow protective power, which is the president's inherent authority, as Steve and Mary just talked about, to protect federal buildings, federal personnel, and that's it. But then later in the brief, there's this very extreme version of the ways in which the government is claiming that they could have much broader power than they're currently exercising. Without me just putting it out, because I know that you and I, Steve, have already talked about this in part, do you want to just describe what the government's argument is and then what you think about it? And then anybody else can jump in.
Sure. So, I mean, just to foreground this just a little bit, right? So the Posse Comitatus Act generally prohibits the military from engaging in domestic law enforcement, but it's only understood as a clear statement rule. In other words, Congress can override it. And when the Posse Comitatus Act was enacted in 1878, everyone understood that the Insurrection Act, which is the not so helpful name we give to actually 5 different statutes enacted between 1792, but 1795 and 1871, that was an exception. I was sort of okay with the government's brief, Ryan, other than where they forgot to put in a table of contents and a table of authorities, right? Up until they make, or at least get very close to making the argument that 12406, this very specific federalization power, is itself a statutory exception to the Posse Comitatus Act. That argument is, I think, incredibly important. I think it's obviously wrong, but it also would be a huge deal if it became part of the story here. What's interesting is it's not really implicated yet because the government hasn't claimed in anything that it's doing on the ground that President Trump's use of 12406 to federalize, 4,000 National Guard troops does allow them to do law enforcement. Right? It's almost more like a defense to the argument that they're going too far past their protective power. And the government's trying to say, well, even if that's true, they're allowed to. Just really quickly, why I think that argument is nonsense. So first, 12406 has mostly been understood historically, since it was first enacted in 1903, as a purely procedural statute, right? That like when the military is otherwise being used for the purposes set forth in the statute, hey, President, you can also federalize National Guard troops. Like, hey, here's an additional body of people who you can bring to bear on the scenario. If that's right, if that's true, then obviously it can't satisfy Posse Comitatus by itself. Second, it came after the Posse Comitatus Act, and this is relevant because it should follow under traditional principles of statutory interpretation that Congress would have to be very specific in a post-Posse Comitatus Act statute that it was satisfying on the Posse Comitatus Act. There's nothing, certainly in the text, and nothing in the legislative history I've seen that suggests anyone was thinking about it. And, Ryan, third, I mean, there is a debate about whether 12406 itself provides a modicum of substantive authority. But even if it does, right, it would, if that's law enforcement authority, then you have sort of a poor man's insurrection act, which, I think just can't, it hasn't been understood that way for 125 years, and it just would make no logical sense to do it. So I actually thought on the merits, the government's protective power arguments were some of the more coherent things we've heard on the subject to date. I have concerns about what's happening on the ground vis-a-vis that argument, and I think that's what the hearing before Judge Breyer is going to largely get into this afternoon. But that was where the government lost me, was the notion that 12406 would itself allow for ordinary law enforcement operations by federalized National Guard. Ryan, in contexts in which no statute authorizes similar behavior by federal regulars.
Yeah, if I could jump into and talk about the part of the brief that talks about the federal protective power, I think it is a little ambiguous whether what they are claiming in the brief is that the federal protective power allows them to do what they are doing now, and those are activities that are short of direct law enforcement, and therefore, because those activities are short of direct law enforcement, there's no Posse Comitatus problem, or whether what they're arguing, which they in so many words they said, is that the Posse Comitatus Act simply does not apply to actions when those actions are, to the military's actions, when the purpose of those actions is to protect federal property and functions. And in support of that second interpretation, which I think is pretty worrisome, and there is some kind of precedent for that because there's something called the military purpose doctrine, under which if the primary purpose of the military's activities is not law enforcement, right? If it's a military purpose, then they can engage in actions that sort of look like law enforcement without triggering Posse Comitatus. So to the extent that it's not clear that the government is making an analogous argument here, that's pretty concerning. That's not something that's supported by any case law, but I think some support for the fact that that is what they're doing is the fact that they've actually authorized the military. They're not doing this right now, but they've authorized them to engage in things like temporary detentions. And, maybe they're saying temporary detentions wouldn't be prohibited by the Posse Comitatus Act. They'd be wrong. The distinction they're drawing between temporary detentions and arrests is kind of maybe imported from the Fourth Amendment case law, where, either of those things, an investigative detention versus an arrest, they're both Fourth Amendment issues, but one of them requires reasonable suspicion, the other one requires probable cause. So to the extent they're trying to import that distinction here, that's not a distinction courts have made. The tests the courts have set forth for posse comitatus is basically a three-part test. And one thing that can trigger posse comitatus is if the military exerts a power over civilians that is compulsory in nature. And so if they are, and also just if you look through the court decisions and the commentary, there's a real emphasis on the role of posse comitatus in limiting and preventing sort of face-to-face direct physical interactions between soldiers and civilians. And so these indirect types of assistance that are permissible under the Posse Comitatus Act, they've been held to be permissible in part because they don't involve these face-to-face physical interactions. Temporary detention is about as compulsory as you can get. It is a physical interaction between the military and a civilian. It should trigger the Posse Comitatus Act. And so I'm concerned that the position of this administration is that they can do law enforcement activities under this federal protective power. And that would bring us into some pretty problematic territory.
If anybody wants to chime in on that, because that is part of where I want to go to next, is the protective power, what it contains and what it doesn't contain. But
sorry, I jumped the gun.
I think it's worth taking a moment, because I'm not sure who all is tuning in today, to talk about the fact that, we say that the Posse Comitatus Act prohibits active duty military or federalized National Guard from engaging in domestic law enforcement. And I think for many people, just the idea of seeing federalized National Guard or Marines out, protecting federal buildings, protecting ICE agents, probably looks and feels like domestic law enforcement. And, to Les's point, over, since the passage of Posse Comitatus, which was just after the Civil War, it's been interpreted, domestic law enforcement has been interpreted rather narrowly in the cases where it's been interpreted. But that narrow interpretation has included sort of these key things like search, seizure, arrest, detention. And so example cases, I think the prohibition, and particularly right after the Civil War, is there actually was an issue, right, of like local officials using Posse Comitatus, using military to go out and try to enforce the law. And Congress didn't want that. And that, as Eliza said right when we kicked off today, it's not like it started, that sentiment started there in 1878. It goes back way before that you don't want your military enforcing law. But I do think there's, for the lay person, it's like, what's the difference here? And the detention issue that Liza raises, I think is the one that gets right close to the line there, because I think what you'll see the government potentially respond if it gets to the point this afternoon, and we'll all be tuning in if we can to the hearing, is suppose the military is protecting ICE agents, right? And suppose there is a direct assault that everyone would agree is an assault on an ICE agent. What are they allowed to do, right? If they lay hands on that ICE agent, on the person committing the assault, and pull that person aside, that's a seizure, right? If they were to say, we're just going to hold you right here until LAPD gets here to take custody, that's a temporary detention. And so that's where I think you start to see this line. And so the question is, when you're talking about the protective power, what does that mean if none of those things are included, even if they're momentary and temporary? Is there anything left of the protective power yet? Do you just have to be out there, protecting, but have local law enforcement or a federal law enforcement agent with police powers standing right by you? Maybe that's the answer. Maybe Liza would say that is the answer. But that I just don't think we've seen that scenario exactly play out that way. And so I think that's why it's dangerous, as Liza says. That's why I think we will see some probing into that probably this afternoon at the hearing. And that's why keeping our eyes open on, will this start to morph into what looks like classic police law enforcement as these deployments, continue.
Ryan, can I just come back to tie Mary's response together to something Liza said earlier? I think there are really two different sets of issues here, right? The first is what the government is doing actually consistent with whatever the scope of the protective power is under Article 2, right? The second is the answer to that question informed at all by the Posse Comitatus Act, right? And, Liza has pointed out, somewhat in this conversation, but also offline, that you could read various OLC memos to be somewhat either ambiguous or ambivalent about whether the protective power overrides Posse Comitatus or whether it occupies all of the space up to Posse Comitatus. Mm-hmm. That's a huge distinction in this context, because how much everything Mary was just saying matters depends upon the answer. So at the risk of sort of being a bit of a nerd for a second, let me take a shot at why I don't think it makes any sense to view the protective power as overriding Posse Comitatus. And the reason is because the founders were so worried about military power that the Constitution specifically gives to Congress, not the president, the power to provide for the calling forth of the militia during domestic emergencies, i.e., to suppress insurrections, to repel invasions, and to execute the laws of the Union. Justice Jackson's concurrence in Youngstown gets taught a lot in law schools, but not the part where he talks about this clause and how it really underscores that Congress, not the president, is supposed to be the principal director of domestic uses of the military for emergency purposes. So it seems to me that, one of the places we might end up in this litigation, if we don't get an Insurrection Act invocation, is actually finally having to put some meat on the bone of where the line is between the protective power and Posse Comitatus and whether they are, in fact, mutually exclusive. I think the historical and founding era and prudential arguments all suggest it ought to be. I worry about the Trump administration toward the end of its brief yesterday, signaling that maybe it's going to try to argue the opposite.
Yeah, and the opposite in a memorandum that applies across the country. Let me end with one other meaty question, and then there's so many questions. I hope that the four of us will just get back together again and have a similar conversation as events unfold. But let me finish with one meaty question. I'm going to try to put two things together that I think do fit together, which is one, a question from the live audience is, don't we have two executives here, the President of the United States and the governor? And therefore, when courts defer to the executive and executive authority and executive decision-making, how do you figure that one out? Because there are actually two different executives that they are in the picture. It's not just a unilateral ratchet towards the president. And then what I want to tie that into is, this is one place it could touch down. Something that we haven't said so far with respect to the protective power is, yes, the protective power might have one or other sets of conduct that it allows for and doesn't allow for. But the OLC opinions are, I think, very explicit that the only condition under which the president is allowed to use military force for the purposes of the protective power is if the state officials and civilian officials, quote unquote, cannot or will not give adequate protection, end quote, to the federal functions, federal buildings, federal personnel. And I think that's maybe, to me, one of California's. I think California has some weak arguments, I'll say that. But I think one of their strongest arguments is the situation on the ground was one in which if Gavin Newsom needed to use the California National Guard, he had that too, and that they were bringing things under control. So just to put the two together, the question of, is there also deference here to the governor as an executive? And does the OLC opinions about this precondition for ever invoking or exercising the protective power kick in as an important guardrail?
Can I take the first and leave the harder second question for Liza and Mary? So I might be idiosyncratic here and I might get myself into trouble, but I don't think I think the Constitution resolves conflicts of executives power in favor of the federal government. And I think we all would prefer it that way. Right. And so change Gavin Newsom, right, to Governor Wallace, right, change it from 2025 to 1965. And now it's a governor saying, everything's fine. I don't need your help integrating the schools, or everything's fine. I don't need your help protecting the marchers from Selma to Montgomery. Right. Like, we should be wary about the substantive and procedural predicates for domestic use of the military. But there's a reason why, going all the way back to the founding, we have not, in many, not all, but in many of these contexts, given governors a veto. And whether this is one where the governor should have a veto because of the specific language of 12406, putting that to the side for a second, I think it's really hard to selectively believe in federal supremacy.
Right. Liza or Mary, do you want to jump in?
Yeah, I mean, I think on the question of whether or not the state was doing an adequate job of protecting federal functions, I think that's highly relevant to whether this was legal or illegal. I don't know that that translates into what the courts will find, because I think the courts will give a lot of deference to the president's assessment that federal functions and federal property were not being adequately protected. So I think there's a potential difference. But I mean, one of the things that this question of federal versus state sovereignty raises, and I think certainly as a sovereignty question per se, Steve is of course right. I think where it becomes relevant is that basically where military deployment in these scenarios is appropriate is these kind of civil unrest scenarios or protecting federal property scenarios is basically in one of two situations. One is where, the state is literally doing nothing because they are on the same side as the protesters, essentially, or in the case of the civil rights era, they're on the same side of the violent white mobs. So they're doing nothing to protect, the civil rights marchers or, African Americans who are trying to go to school, right? So in that situation where state and local law enforcement is just sitting on its hands, right? Then you might need to send in the military. In a situation like this, where quite clearly that's not the case, right? And we've all seen the videos of LA police, using pepper spray and tear gas and throwing flashbang grenades, right? So they were trying to address the situation. So that's the situation where if they are in fact truly overwhelmed, the person in the best position to know that, the people in the best position to know that are the local authorities. If the local authorities are trying to protect the federal property, they're trying to quell the civil unrest, but they need reinforcements, they will ask, right? So the lack of the governor's request in this case is not, to me, a sovereignty issue. It's an issue of whether the sort of criteria for deployment are met. But again, I think that is more of it's an issue of both what the law says, how the law has historically been interpreted when it comes to domestic deployment, and maybe less how it's going to play out in the courts.
Right. Mary, just want to give you last word on that particular topic or anything that we've discussed or you're thinking about.
Sure. It's interesting because we have two things going on here, right? We have the presidential memorandum that starts out, right up at the top saying it's relying on Title 10, Section 12406. And there's only two provisions of that could potentially be applicable here, because the provision number one is invasion by a foreign nation. Now, granted, put aside for a moment what he has said.
We're being invaded, Mary. We're being invaded.
He hasn't said that on the protests in LA. I mean, Stephen Miller has said they're flying, Mexican flags and other flags and called it invasion, but that's not in the presidential memorandum. So putting that one aside, notwithstanding what he said about Tren de Aragua and the Alien Enemies Act, he does talk about a rebellion or danger of rebellion against the authority of the government of the United States. That's what we talked about early in this discussion. And he talks about the president being, he talks about that activity inhibiting the enforcement of the laws of the United States. But the fallback clearly is the Constitution. What we've been talking about here is what are the limits on the protective power to the extent that derives from the Constitution. And some of that I think will get probed this afternoon. The other thing I think that will get probed, though, is are the criteria of 12406 met? And, this is an area also where there's tons of deference given to the president when it comes to things like that involve national security and emergencies and what's an insurrection, what's a rebellion. And so, of course, the government's position is you can't look at this at all, Judge Breyer. But I do think this is where it's important to think about what the Supreme Court recently said in the JGG case. That was one of the first Alien Enemies Act case to hit the court's emergency docket. And, there the government also said, courts, you can't review whether there's an invasion or predatory incursion from a foreign nation because that is committed entirely to the president's discretion. And the Supreme Court said, while not ruling on the merits of that, said that people subject to this are entitled to due process and can raise issues, and courts can decide issues about the interpretation of the congressional statute and its constitutionality. So I think there is an argument here that what is a rebellion, based at least on what the president has called a rebellion in his presidential memorandum, is something that the judge can interpret. What is Congress's the meaning of the words Congress used in 12406, and does what the president has alleged, protests or acts of violence that directly inhibit the execution of federal law, is that a rebellion under the text of the statute? And also they can interpret what this clause that says issues shall be ordered through the governor. Does that mean the governor has a substantive say, or is that just purely procedural, like they've got to go through the governor? I think what the U.S. says in its responsive brief is it did go through the governor. The memo went to the adjutant general saying through the governor of California. So, there'll be some probing of that. And so I do think those interpretation questions are things that the Supreme Court has recently suggested are reviewable. Getting into facts on the ground and whether those facts on the ground meet rebellion is a trickier question, because that starts to sound a lot like whether facts support an insurrection for purposes of the Insurrection Act. And the Supreme Court said many decades ago that that's something that is within that's within the president's power solely to determine. That's been undermined a little bit by case law that suggests, we assume good faith in that. And so there might be some wiggle room there, that when it's so obvious that the facts on the ground don't meet whatever the president has said they are, rebellion, insurrection, what have you, there is some room for courts to get involved. But these are all questions we don't have answers to yet.
Yeah, and yet is a good way to end this. Stay tuned. Mary, Liza, Steve, just so grateful to you, because you are the folks who have done the most amount of thinking about this, not in the last 4 days, but in the last several years. And your erudition and the ways in which you approach these issues are really a national treasure. So really appreciate it. Thanks everybody for joining. Feel free to engage in comments after the live YouTube, and I'll engage in comments with you. I'll be reading those and responding as I can. So thanks everybody for joining us. This episode was hosted by me, Ryan Goodman, and produced by Maya Neer with help from Isaac Rubenstein. Special thanks to Liza Goiten, Mary McCord, and Steve Vladeck, as well as to the Reiss Center for co-hosting this panel with us. You can read all of Just Security's content on civil military relations, domestic use of the military, and law enforcement on the Just Security website, including audio recordings of our most recent articles. If you enjoyed this episode, please give us a 5-star rating on Apple Podcasts or wherever you listen.